Welcome everyone to tonight's Merton conversation on liberty. Now I imagine just about everyone in this room will be aware that 2014 is the 750th anniversary of the foundation of Merton College. Our college and our statutes have served as a template for other colleges through time and throughout the world. We are immensely proud of this. In the course of this year, we've put together a very full and varied programme of celebratory events, and it's been our intention to use them to draw together the Merton family. And by that I mean our fellows, our students, our staff, our alumni, and of course our friends. We have celebrated not only with special birthday weekend and a summer ball and many excellent musical events, but also by discussing across the world some of the great global issues of our time in this unique series called The Merton Conversations. But before I welcome tonight's two discussants and their moderator for the Merton Conversation, I'd just like to give you a brief update on another equally important aspect of the anniversary, and that is the 750th campaign. As the Mertonians amongst you will know, our campaign target has been £30 million. And this is needed really to help us secure the college for the next stage in its history. Now, one's often warned in life not to declare victory too soon. Well, the problem with me is I may well be declaring victory too often. I announced it twice at the birthday weekend. I'm announcing it again, and I shall continue to go on announcing it till the end of the year. I'm absolutely thrilled that we have made this target. And I want to thank you all for your generous support, which has enabled us to reach this. Really, it's a very challenging target for the size of population that we are. And I should remind you what this is for. This will enable us to strengthen the tutorial system, to support our students, and protect and resource the college's historic buildings. I should actually just add that we still have a little way to go in one or two aspects. So in particular here I'm thinking of the undergraduate student support. I'm thinking a little about the law fellowship, which is sort of specially relevant tonight, and also, of course, towards the college's boathouse. There's things that are not quite finished just yet, you know. The boathouse will take a little time, I suspect. And in particular, I would like to thank the college's previous warden, Professor Jessica Rawson, that should be, who is here with us tonight, who in 3 years managed to raise the amount of 13.4 million, so that by the time I came, with the four years to go, nearly half of it was in the bag. That gave me a terrific platform to work from. So now let me turn to the Merton Conversations again. As you may well know, there are 6 of them. We began with one in Hong Kong, we have 4 in the United Kingdom, and 1 in New York. I'll say a little bit more about them. They cover, as I mentioned, some of the 21st century's key issues. Now, we began in Hong Kong in January with the challenges of global finance. And then we picked up again with China in our second conversation in Oxford in February with the topic China and the West, Culture and Society. And we then moved on in April to discuss in New York the global media revolution. And our next discussion was in May at the Royal Society on the topic of the 2 cultures of C.P. Snow. And now, tonight, we are delighted to be here for the 5th of our 6 conversations, this one, of course, on liberty. Thank you, Brian, Shami, and Philippa for being here with us tonight. In a moment, Philippa Whipple, who is our moderator this evening, she'll present Brian and Shami properly. I just want to say thank you to them. But my remaining task then is to introduce our moderator, Philippa, tell you a little bit about her. Philippa read law at Merton before becoming a solicitor at Freshfields. She worked there for 5 years before coming as a pupil to number 1 Crown Office Row, and she was called to the bar in 1994. After taking silk in 2010, she was appointed lead counsel to the Detainee Inquiry. In addition to what we might call her legal life, Philippa is a very enthusiastic and wonderfully committed Mertonian. So that's nearly perfect as far as I'm concerned. Well done, Philippa. She has been the chair of the Merton Lawyers Association since its launch in autumn 2006, and she is a member of the Mertonian Society Council, and of course she's doing this for us here tonight. Ladies and gentlemen, will you please give a very big round of applause to tonight's moderator, Philippa Whipple.
Thank you, and thank you, Martin, for those very kind words. Well, ladies and gentlemen, welcome to this, the fifth in the series of Merton Conversations to mark the 750th anniversary of the foundation of Merton College. I want to take a couple of minutes at the beginning of this evening to reflect on the reason for tonight's conversation and set the scene for our discussion on liberty. I wonder if the lights can just go down, if that's possible, please. Can the lights go down? Perhaps the lights can't go down. Let's carry on. This year, thank you, we celebrate the anniversary of the first of Merton's statutes, which were given to the college by its founder, Walter de Merton, in 1264. Walter de Merton had started life as Walter of Basingstoke, so but for a couple of twists of fate, we might have been here tonight to celebrate the foundation of Basingstoke College, not, perhaps, the most inspiring of college names, although those of you who may live there may think it a fine place to be. Walter took up work as an administrator at Merton Priory, and from there he moved into the service of King Henry III, working his way up the Royal Chancery to become the Chancellor and the head of Royal Administration in 1261. By that time, he'd become known as Walter de Merton. As he rose, supported by royal patronage, he collected posts in the church and he purchased land. His plan was to make an educational endowment to support students at Oxford. But his first attempt failed. In 1262, as tensions between the king and the barons, led by Simon de Montfort, spilled over into civil war, Walter de Merton lost his chancellorship, his lands were ravaged, and the endowment couldn't be made. It was only 2 years later, in 1264, when tensions had eased, that Walter was restored to his properties, and then it was possible for him to rekindle his plan. This time, the endowment was made. The 1264 statutes were in place. Further statutes followed in 1270 and 1274. These three sets of statutes established the college under the governance of the warden and fellows and under the ultimate supervision of an outside visitor. It is worth noting that the statutes require those governing the college to deal with each other in such a way as to preserve unity and mutual charity, peace, concord, and love. This possibly is a tall order. One does wonder whether the warden and fellows have, in the intervening 7.5 centuries, always been as wholesome as Walter envisaged, and I invite Martin perhaps to comment on that in his closing comments. In the 1280s and the 1290s, after Merton's foundation, the college buildings started to take shape. Work was underway to erect a muniment room, the new college chapel, and shortly afterwards, of course, the foundations of Mob Quad were laid. This lovely Mob Quad, so familiar to many of us. And these parts of the college survive to this day. The world into which Merton was born was rapidly changing. There were tensions between the monarchy and the aristocracy. In 1215, just 49 years earlier, King John, the father of Walter de Merton's patron King Henry III, had settled his dispute with the barons by a pact signed at Runnymede. You know what's coming. The document was in Latin. Its long title was The Great Charter of the Liberties of England, and it has become known as the Magna Carta. The majority of its clauses dealt with the regulation of feudal customs and the operation of the justice system. Most of the document is now obsolete and has long since been repealed. But 3 clauses remain on the statute books today. The first deals with the freedom of the church, the second with certain liberties of the City of London, and the third, which is in fact an aggregation of 2 clauses in the original, clauses 39 and 40, provides as follows. This is a modern translation by the Constitution Society, but we see here, no freeman shall be taken or imprisoned or disseized or exiled or in any way destroyed, nor will we go upon him nor send upon him, except by the lawful judgment of his peers or by the law of the land. To no one will we sell, to no one will we refuse or delay right or justice. And look what you see here. You see here the prohibition, if I can do it. No freeman shall be imprisoned, the prohibition on unlawful imprisonment. And that's where the doctrine of habeas corpus comes from. And that's the right of any person detained by the state to be brought before the court to complain that his detention lacks lawful authority. You see here the very beginnings of trial by jury, judgment by your peers. You see the guarantee of the rule of law, judgment according to the law of the land. And you see the guarantee of the right to impartial justice. To no one will we sell right or justice. The undertaking that no right or justice can be bought or delayed. Well, ladies and gentlemen, these are fundamental rights. They're now embedded in our constitutional law and widely recognized as the foundation of a modern democracy. And although this document wasn't understood in 1215 to be the start of a new constitutional order, recognition of its significance grew in subsequent years. The document was relied on by Sir Edward Coke, the great Elizabethan jurist, in his writings in the 17th century. It inspired the early settlers in New England. In time, it found echoes in the United States Constitution. And when the Universal Declaration of Human Rights was adopted in Paris on the 10th of December 1948, and you see here a picture of Eleanor Roosevelt holding the product of so much of her work and the work of others, she said of it that the Universal Declaration may well become the international Magna Carta of all men everywhere. The European Convention on Human Rights was signed 2 years later in Rome, and the debate around it and the role the Strasbourg Court holds in interpreting it remains high on our political agenda even now. And so we come back to Merton. This is the feel-good moment for all the Mertonians in the audience. There are connections between Merton and Magna Carta. Both are creations of the medieval age. Both still play important roles in contemporary society, and both will doubtless continue their evolution to meet new challenges. There is also an obvious connection between Magna Carta, that great constitutional document, and our modern understanding of human rights and civil liberties. And so Magna Carta is a good place for us to start this Merton conversation on liberty. Let me then introduce tonight's speakers, and if we can lift the lighting again, that would be very good. To introduce tonight's speakers, for me, is a very easy job because you know them both already. They both belong to that small club of household names who are also lawyers. Brian, first, let me introduce the Right Honourable Sir Brian Leveson. After a successful career as a barrister, Brian was appointed to the High Court in 2000, rising to the Court of Appeal in 2006. This is lightning quick. In 2011, he embarked on his inquiry into the British press. The inquiry hearings, let me tell you, this is an interesting fact. The inquiry hearings commenced on the 14th of November 2011. The full report was published on the 29th of November 2012, just a fraction over a year later. Again, lightning quick. It's a Leveson trademark. Last year, 2013, he was appointed President of the Queen's Bench Division of the High Court. Brian is a Merton man and currently President of the Merton Society. Brian was particularly kind to me many years ago when I was a faltering pupil attending an advocacy training weekend in Oxford, and he drew the short straw as my advocacy trainer, and he had a great deal of work to do. Ladies and gentlemen, Brian Leveson. And Shami Chakrabarti. Shami joined Liberty the day before, this is famous, she famously joined Liberty the day before the 9/11 attacks, and she's been a powerful voice in support of fundamental rights and freedoms since then. She became the Director of Liberty in 2003, a role she still occupies. Shami knows precisely what target she's aiming at. Before she joined Liberty, and when I first met her, she worked as a Home Office lawyer, and on the other side of the fence, she found herself defending the government in Strasbourg and the domestic courts, and this was surely invaluable training for her later career. In 2011, she joined Brian as a panel member on his inquiry into the press. She has very recently published a book entitled On Liberty, in which she discusses the high-profile campaigns that she's been involved in, such as ID cards, 42-day detention, and imprisonment of foreign terror suspects without trial. Shami has been a good friend to Merton. She was the speaker at one of the first Merton Lawyers Association meetings, and I understand she also spoke at a Hallsbury Society dinner in college. We are very pleased to have her here this evening. Shami. Good. I wondered if we could open the conversation this evening on the subject of Magna Carta. And perhaps I can ask you, first of all, Brian, whether you see a connection as you sit now in your role as a judge with the principles as they were first set out in Magna Carta.
There's no doubt about that at all. You mention habeas corpus, you mention the right to be tried by one's peers. Of course, it was Henry II that had judges going around the country and introduced trial by jury before John, but Magna Carta identifies the importance of it. You mentioned the way in which judges must behave, and I think that each one of those features of our modern society is reflected back to 1215. The British judiciary, I claim no credit for this, has a very high reputation in the world. And I think that's in large part due to the way in which we're trained, to the way in which we take so many fundamental tenets absolutely as our bedrock. So I've no doubt at all that one of the reasons for our success is that we are so well grounded in principles of fairness and natural justice. The terms of the judicial oath are to try all manner of people without fear or favour, affection or goodwill, according to the laws and usage of the realm. That language echoes precisely the translation that you've shared with us.
Shami, can I ask you then, what do you think, if anything, Magna Carta contributes to the contemporary debate?
I think it's mostly important as an inspirational influence. I actually quote a great English jurist at the beginning of chapter 3 of my little book. So I won't bore you with it. Actually, won't keep you up too long if you are interested. My 12-year-old says it's a short book, Mum, with very large font. It's less than 150 pages, and it has the Human Rights Act at the end. And a lot of people haven't read that either, like Magna Carta, which is why I think it was so good that you actually put it up on the screen. So this is a very famous English jurist who will be known to some of you, who said in 1959, "Does Magna Carta mean nothing to you? Did she die in vain?" Who was that? Who was that? Come on. Yes, that's right. That's from Hancock's Half Hour in them. But seriously, it is mostly inspirational now, I think. And I think, and a lot of people, and that's great, because when something acquires a constitutional status, it's got to be a little bit semi-sacred. Mm-hmm. And if human rights instruments and constitutional instruments don't acquire that sort of semi-sacred status, we have the problem, shall I say, that we're experiencing at the moment in this country, I would argue, with the Convention on Human Rights and the Human Rights Act, where it's all fair game, and one party says it's Labour's Human Rights Act, and if we're not careful, you get into sort of permanent constitutional revolution where every new government is going to scrap the human rights instrument and replace it with their own thing, which I personally find troubling. I think that to go back to the clauses that you put up on the screen, you see there the importance of an independent judiciary. You see there the importance of, I would argue, legal aid. If in reality people are not going to be denied access to justice and it's not going to be delayed, then they need, in my view, legal aid. And we've seen the near decimation of legal aid, even in our professional lifetime. So yes, it's still there for inspiration, but sometimes I would argue, and it's not a party political point, the political classes like to wrap themselves in the flag of Magna Carta, but don't actually like the reality. And I'm interested that next spring, when all the celebrations begin, and you know, the Magna Carta is, of course, there's one in the British Library, and there are I think 3 others, and they're all going to be brought together.
I think they have now all just been brought together.
There's going to be, and there'll be politicians from across the piece, across the spectrum, saying Magna Carta this, that, and the other. But at the same time, they want to rip up the international human rights instruments that were inspired by Magna Carta. I once said to a senior politician who said, "We don't need the Human Rights Act, Shami. We've got Magna Carta." And I'm like, well, where does your, I mean, great, you've got your habeas corpus, that's important. You've got the beginnings of jury trial. You've got, I would argue, maybe Articles 5 and 6 of the Human Rights Convention. That's the right to liberty and the right to a fair trial. You could say they come from Magna Carta, but you don't have your right to free speech, your right to freedom, thought, conscience and religion. You don't have equal treatment under the law. You don't have, you know, so many of the other rights and freedoms that are just as important. And I would say of the habeas corpus and jury trial rights, they don't become any less precious or important when translated from the original Latin into English, or indeed into other languages around the world. So I'd say it's the beginning of, just as Shakespeare isn't the end of English literature, Magna Carta is perhaps the beginning, or one of the beginnings, of our human rights journey. And I think we're allowed to, you know, to go on, in particular to the post-war period.
Of course, one of the interesting things about Magna Carta is it did take quite a long time before anybody even thought of it as a seminal document, and it was much disputed in its early stages.
A lot of it was a bit of a grubby deal between the barons and the king.
There was that, yes, dealing with the forests. Can we look at the legal system itself? And in a forum like this, obviously one can't cross too much territory, but really just to look at where we've got to, given that our legal system might find its origins in that document. And look first of all at the role of the judges. And the question for Brian, having such experience, long and valuable experience as a judge, is what do you see as the essence of judging?
Well, society needs mechanisms to resolve disputes. Disputes between citizens, who's responsible for the road traffic accident, disputes in families when they break down, disputes between contracting parties, and equally disputes between the citizen and the state. And the role of the judge is to provide an independent mechanism for the resolution of those disputes. I frequently say to new judges, I ask them, who is the most important person in court? And the answer I provide to my own question is, it is the person who's going to lose, because that person has to feel that they've had a run for their money, they've had a fair hearing, even though they might disagree with the result. Actually, normally, everybody's pretty disgruntled because the winner feels they've won something which they thought was obvious. They were obviously right, and it's cost them far too much money. And the loser can't understand the idiot judge for reaching the conclusion that he reached. But I do think it's important to focus on the parties and to make sure that the person who loses at least can't complain that the judge was biased or didn't think or didn't pay enough attention to the arguments. The other aspect is to recognise, and I say this to judges, that we're not superhuman. how do I know who was the one that crossed the red light?
Yeah.
The answer is I wasn't there. I've had witnesses tell me what they saw. I've got people to talk about the engineering of the lights to make sure they were working correctly. But at the end of the day, I have to make a finding of fact on a historical event. Now, am I right every time? I can't tell you. And it was a very significant recognition for me as a very young assistant recorder in the 80s that when I suddenly worked out I wasn't being paid to get the answer right. I was being paid to do my very best to get the answer right. So I'm constantly looking for ways to test the straight conflict of evidence. So I can look at the facts that I know are certain, and then the things which seem legitimate inferences from those facts, and then fit the facts together. And it's easy if you've got lever arch files of paper, because the paper there will help you. The problem is where you haven't, and you can't actually read somebody's mind. So the most important attribute to my mind of being a judge is humility. You've got to be able to identify that you are no better a human being than anybody else, but that society has to have a solution. They can't allow the problem to go unresolved, because in that way it becomes the law of the strongest.
Shami, do you think we appoint the right people as judges? Present company excluded.
I'll say two things. I'll say what I should say, and perhaps something else as well. I was listening to Brian before he got to the H word, and I was thinking humility, 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 and of course, and you heard it from Brian, right? So he is the personification of that judicial humility. It isn't enough to be a desperately clever lawyer, in my view. You've got to have that humanity as well, because in the end you're doing justice for people, and some of these people are at the worst moment of their lives. Nobody wants to, generally speaking, people don't want to be in court with their child to lose, or facing deportation from the country, or their liberty to lose, and so on. But I do have to make a point about greater diversity, and I make that for two reasons. One is that I don't believe that there's a choice to be made between merit and diversity, because I'm a human rights campaigner, and so I care about all kinds of injustices, but my view is, my 45-year-old view, as opposed to my 25-year-old view, is that gender injustice is probably the biggest, oldest, deepest, most entrenched injustice on the planet. It's a kind of apartheid, but it's a global apartheid. And I also think that cracking it, or beginning to crack it, would be incredibly influential on other problems as well, like development and all sorts of other issues. And I would like to see a more diverse judiciary in the UK, and in particular I'd like to see more women. And I'd like the pace of change to be quicker. Perhaps I'm getting older, and so I'm getting more impatient to change. They call me the most dangerous woman in Britain. That's the Sun newspaper funny. But I also think, given the judge bashing, to be blunt, the judges are generally pretty humble. There are some exceptions, and we'll talk about that over a drink later. But generally speaking, the senior judiciary in this country is humble, and constitutionally humble, and very deferential to the appropriate role of Parliament, for example. The political classes, in my view, are not so humble. And to be blunt, there has been a lot of judge bashing in recent years, and we've all heard it from senior politicians and from the media, and the bits of the media that Brian knows all about. And I actually think that it would also be helpful for that conversation. It would help to inoculate the judiciary and the concept of the rule of law a little from some of that very, very populist and dangerous judge bashing.
And personalised.
And personalised judge bashing, if the judiciary looked a little bit more like the people. Of course, you know, Brian is a white man. I could get justice from Brian. There's no question about that. It's not that's not the point. It's just that you know it will be better for the legitimacy, the popular legitimacy of that vital institution, if it's more reflective of society. You spoke earlier, Philippa, about Magna Carta as the beginnings of democracy, and that's really interesting because so many senior politicians that I talk to don't understand. They just do not understand. These are very clever people of my age, because I'm a middle-aged woman now, so the Prime Minister and all these people are about my age. I hate it when that happens. It's like when I was a kid and I realised I was never going to be an Olympic gymnast or a tennis player. Or it's now happening with the politicians. And some of them, really clever senior politicians, don't understand that that elected power is not the only legitimate power in a democracy, and that you do need to have independent referees and the rule of law in order to so that people honour the bargains that they've struck with each other, so that people don't rob each other, and etc. 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 And I've heard so many senior politicians. It's not a party political point. Say these unelected judges, who do they think they are? Now, I'm sorry, elect the judges and Barabbas will always go free, right? And so, you know, that is the challenge that we're up against. And I think that a more diverse, more reflective judiciary would just help a little bit, I'm afraid, with that PR.
I've no real problem with increasing diversity in the judiciary, but I do think that, and I think we can speed up, and we are speeding up. There are now 20% of the Court of Appeal, 20% of the High Court bench are female. We're very bad on BMEs, there's no question. But one's got to remember where we start from. The people at my sort of level inevitably started as lawyers when I started as lawyers, and I grew up as a barrister in Liverpool, where there were about 100 barristers, and there were only about half a dozen women practicing at the bar and not very many solicitors. Now, everybody says, well, there are able people, and I've no doubt there are. And what we've got to do is encourage the able to be prepared to take on judicial responsibilities. And we're trying to do that in ways of, in many different ways, by being much more user-friendly for those with caring responsibilities, by taking account of the needs of women and others, and trying to encourage people who may never have thought of a judicial career to come and follow a judge and to get some experience so they can demonstrate they have the potential to develop the ability. So I'm not being complacent about it, and I respond only because I wouldn't want you to think that I'm sitting comfortably as male and stale and wanting to replicate myself. It always irritates me when people say, well, you just want to appoint people in your own mould. I'm not that pleased with myself. I'm sure that you can do a lot better than me, and I'm happy to find the very best, but finding the very best is critically important. And I'm prepared to say immediately, before you jump in and say it, that I am not saying that merit and diversity do not live perfectly well together. I think they can. But I'm sure you wouldn't want to start, well, I don't know whether you want to start quotas. I personally would be against quotas, but I would do everything I could to encourage capable women and from black and minority ethics to become judges.
In the Supreme Court, we always have a Northern Ireland judge in the Supreme Court. We always have a
Scotsman or two, I think.
We have two Scotsmen and one Northern Irish.
Well, that's
judge.
a sort of quota, isn't it? Just to be controversial.
Well, yes, but with great respect, of course, which means quite the reverse.
None whatsoever.
That court...
You've had that said to you a few times, haven't you?
That court deals with Scots law and Northern Irish law, and therefore you do need to have somebody who understands something about Scottish law and Northern Irish law. And indeed, there's an argument that with the Assembly developing more and more in Cardiff, there ought to be a Welsh lawyer. I mean, there are real arguments about it. You're not so convinced?
No, I think that I may be bending towards what you would call quotas, actually. I think I'm too impatient. I think that if a Pankhurst were to look at a Chakrabarti, she would not be so impressed with what we've done as feminists in my generation.
Well, I would like you to look at something slightly different. I would like you to look at the number of women of your age who could be thinking about starting a judicial career. There you are, Shami.
Well, hopefully, Philippa. I mean, you're sort of.
Perhaps we could just have an informal little interview session here, and we could just shoo it in.
Do the anointing
He's got
now.
The power.
I have no power.
Humility, no power.
Yeah, absolutely. But the numbers that there are now coming up are vastly different to the numbers 10 years ago, and you can't grow them quickly. So I understand the point. I think that we send the wrong message out if we have quotas. I think that's part of it. I do think there are people out there, and what we've got to do is to get them to apply and get them in. But if you look at our appointments over the last few years, I think you'll find that the diversity has increased really very dramatically, and that's good. I'm not saying
I shouldn't even say diversity, because women, we're half the human race. This isn't diversity. This is just this
You're
terrible
probably more than
gendering.
half the human race.
We probably are. Yeah.
And we all know who the most powerful half are.
That old chestnut.
Yeah. Flattery gets you over.
I was actually looking at my wife.
Let us talk a little bit about the criminal justice system, if we may. In terms of developments over the many intervening years since Magna Carta and so on, we have developed a system of jury trials. That is sometimes an interesting discussion, and sometimes it's suggested that the jury system isn't working as well, perhaps, as it could or ought to. Shami, what do you make of the jury system? Do you think
it depends what you mean by working. You see, I think I believe in jury trial for serious offences, where people are going to have substantial loss of liberty, and I think it's been like the judiciary, like the rule of law, that the concept of jury trial has been denigrated by successive governments, particularly during the New Labour phase. And this idea of it not working rather depends on what working means.
Yes.
And there was, again, I talk about it, I mean, there was this suggestion that really the criminal justice system should be a sausage machine that gets people to jail as quickly as, that takes people from the street. Yeah, everyone's guilty
Everyone's
until...
guilty.
Well, I mean, Mr. Blair famously said, the concerns of a 19th century criminal justice system were too many of the innocent being convicted, but today in the 20th century the concern is too many of the guilty going free. So he turned Blackstone's famous quote and turned it on his head deliberately to shock the sort of bleeding heart liberals like me, and to show how tough on crime, tough on the rhetoric of crime or the causes of crime.
Causes of crime.
And I think jury trial is really important. Without it, one class is always sitting in judgment over other classes. I think it's a very important part of democratic engagement, actually. If you've ever had a family member or a secretary or someone who's got nothing to do with the legal system, but they've been called for jury service, it's often transformative, actually. And they come back and they talk about how seriously they took it. So obviously it can't be for every minor infraction, and so it can't be an absolute right. But I do think for more serious offences where you're going to sustain a substantial loss of liberty, there's still nothing to beat it.
even if, and the debate often centres on cases where there's a lot of information, perhaps fraud cases, a lot of financial information, and they're going to be very long cases.
I don't buy this. I think that's just bad advocacy. If you can't present even complex facts, particularly these days, with all the visual aids that ought to be potentially available, and all the ways of presenting evidence and information in a more accessible way, I don't buy the idea that ordinary people can't deal with facts well presented in a court setting.
Brian, you have huge experience of in the criminal courts, not of course on.
Yeah, I've sat in most seats. I've sat in most seats, but not that one.
Not that one. Not that one. What's your experience of the jury trial? Is it an effective means of securing justice?
Well, I go back to one of my earlier answers. I wasn't there. I don't know. But I do believe that the public in this country have enormous confidence in the fact that serious crime is tried by those who are not professional players in the justice system. And it is only very rarely, my view of course doesn't matter, but you can't sit in a trial without forming a view unless you're broccoli. And therefore, of course, you have your view.
That's broccoli the vegetable, not the famous film producer.
Correct. It is broccoli the vegetable. So you might privately think, well, this is how I would go. You never ever identify it. And one of the aspects of trying crime that I found most interesting and enjoyable was to try and present the arguments and the facts square. Square didn't mean 50-50 because the facts never were 50-50, but in such a way that the tenets of both the prosecution and the defence could be understood by the jury. I was never ever in favour. I mean, when I started the bar, judges would make some horrific comments, but we're about what they thought of the facts. But I studiously avoided them. But I don't think I often personally would have reached a different verdict to the jury. There are occasions when I would, but I recognise that I'm not a 13th juror. It's just not for me to decide. It's their decision. And I welcome that. But I think Shami identified two critically important caveats. Because she talked about serious crime and substantial custodial sentences. I might be slightly less than substantial, but what I am concerned about is the decisions that have to be made at our present time of government financing. And one of my concerns about the system as it operates now is that people are called for jury service. It's tremendously expensive, and then they find themselves trying a shoplifting case or a really quite trivial punch-up, and they think, I've had to take 2 weeks off work, I'm not being paid my wages, I've got to survive in some way because the amount the state provide to jurors doesn't necessarily reflect what they earned, and I've had nothing to do, and I've hung around a lot waiting for something to happen, because you always need more jurors than you actually use. So there is a very important policy decision to be made, and I say it's a political decision, it's not a legal decision, as to whether we ought to revisit how we balance who should be entitled to trial by a jury and who shouldn't. And that's...
should pay the jurors.
And who, well, but who else can pay the jurors?
Well, maybe your employer should have to just take the hit for a few weeks or whatever it is. I mean, if you think about maternity leave, I don't know, is it important enough to us from a policy point of view that we have jury trial and that people have the opportunity and the duty to serve as jurors?
Now,
I think employers do continue to pay the ordinary salaries. They only get a small, jurors get paid a small amount.
Some do and some don't.
Some do and some don't. The corner shopkeeper, whose employee goes off may not be able, and has to employ somebody else to help in the shop.
Well,
I'm not.
Sickness, pregnancy. I'm saying these are all, you know, these are all.
But Shami, do you
Yeah.
agree with that proposition that resources can come into the issue of who gets a jury trial and who doesn't get a jury? State resources
Well,
can
of course,
be
because
relevant.
otherwise I would, you know, I would support, you know, jury trial. Resources and time
Yeah.
must be relevant, because otherwise I would be taking a purist position and saying that, you know, every crime of dishonesty or every crime should warrant jury trial, and I don't say that. So I think that it is about the gravity of the charge in terms of the opprobrium, you know, to.
Yeah.
But also I think we're talking about substantial loss of liberty. I think it's that blend of opprobrium and serious punishment that really ought to warrant your the 12 good men and true and your day in court with a jury trial.
I agree with that entirely. Of course, at the moment, you can elect trial by jury on any trial either way. So any theft the defendant can
you
elect
can go to
trial by
prison,
jury.
but on an either way you can go to prison for quite a long time.
Well,
and that's the other
you
thing.
wouldn't for pinching a sandwich.
But we could say, let's not have, let's be more liberal about sentencing. Let's not have longer and longer sentences. Let's not imprison more and more people in this country, and then you wouldn't have to have so many jury trials. That's another way of approaching it.
What do you make of that, Brian, as the contributor and I think president of the Sentencing Guidelines Council?
I was the chairman of the Sentencing Council for 4 years. There is no doubt that sentences over my professional lifetime have increased, and in some cases increased dramatically. That really is a reflection of the deference that judges pay, and they're required to pay, to Parliament.
Absolutely.
And not just to Parliament, but also to public concern. Because one of the aims of punishment, originally identified by a man called Montereau, was to prevent people taking the law into their own hands. And there is no doubt that Parliament has stepped in to the crime of murder and required judges to sentence at levels which are very, very much greater than those which came beforehand by the 2003 Criminal Justice Act. And I'm talking about changed in the last, in my time on the bench.
Of course, you have to be more careful about what you say than I do, Brian, but I basically think that there's been a terrible authoritarian arms race in British politics that's gone on pretty much for my adult life, certainly since I was called to the bar, so certainly for the last 20 years, with both major political parties trying to out-tough each other on law and order and terrorism and all the rest of it. And I think some of it's been downright irresponsible, and I think it's been really poor leadership, and at times it's been very misleading. So for example, in the context of murder, how many times have you read a newspaper report or heard a politician or whoever say, it's outrageous, this terrible, terrible axe murderer has only got 10 years, as if that was the sentence, when we all know that what they got was life, because it's a mandatory life sentence, but 10 years was the tariff before which they could even be considered for potential, all of this.
But axe murderers wouldn't have got 10 years
Well, exactly.
determined term anyway.
Exactly. But you see my point. They play politics with this stuff as a distraction from other things, the economy, and their own feelings of I don't know, sort of powerlessness in the face of really big, difficult problems, and they play politics with law and order, and I think it's really bad for society. It's really bad for the rule of law.
Well, you're absolutely right, Shami. You say things that...
that you can't say.
What I will say, what I'm happy to say, is that I've been a lawyer now, practicing at the bar and on the bench for 45 years, 44 years. And there used to be a Criminal Justice Act every few years. Now, there is criminal justice legislation every single year. And trying to keep up with it is almost impossible. And the consequence is that errors are made and all sorts of problems arise simply trying to keep up with the pace of change. But there's no doubt that we have become much more penal as a result of the approach of politicians in legislation, which itself, I believe, has responded to press and media attention.
It's the over-criminalisation of behaviour that doesn't necessarily need to be criminal. Kind of things that used to be nuisance are now antisocial behaviour.
So getting into ASBO territory.
Getting into all of that, and of course the whole ASBO regime, again I talk about it in the book, became a shortcut into the criminal justice system when it was supposed to be a way out of the criminal justice system.
Yes, the great thing about ASBOs, and I'm perfectly happy to say this because I've said it publicly many times, is that ASBOs, as antisocial behaviour orders, criminalise behaviour which isn't otherwise necessarily criminal at all. So you've got somebody who causes a nuisance on the estate. So you say, well, you can't go onto the estate. They draw a circumference around an area and say for the next 2 years or 5 years, you can't go into that area. And if you do, then you're committing a crime for which you can be ultimately sent to prison.
So it's all part of this, trying to catch people, trying to avoid the due process protections that you put up on the screen, trying to avoid the presumption of innocence, trying to say we haven't got enough to charge you properly and to convict you in a traditional criminal trial, so we will make this injunction that you don't walk on the cracks in the pavement,
basis.
and when you do walk on the cracks in the pavement, we've got you, you've committed a criminal offence.
But Shami, do you think that there is, whether for good reason or bad, a substantial public appetite for criminalisation and for harsher measures for law and order? In other words, is it too easy just to blame the politicians and perhaps the press in turn that this has all actually been being
well, I suppose
driven
we're all
by
in
public
it. You
opinion?
could say we're all in it together,
Yeah.
but I rather look at, I mean, you know, the thing about the press is that at the end of the day, you spend a few pence on your newspaper, and actually increasingly people don't, which is one of the reasons they're in such a panic, as Brian knows from his inquiry. But my vote is rather more precious to me than the few pence that I spend on a newspaper. And I do think that there could be more leadership from politicians and not just all this opinion poll chasing and focus group chasing and so on. Yes, people want to criminalise other people's children, but not their own. In my experience of doing this work at Liberty for 13 years now, everybody loves human rights, their own. And the human rights of other people like them. It's other people's children. That's what we really ask. That's what Eleanor Roosevelt and Winston Churchill and all those sort of founders of the post World War II consensus on human rights were asking people to do, to love other people's children as their own. And you don't want your own children criminalised. Do you remember when, sorry to bring it up because people should be able to rehabilitate, but Mr. Blair's, one of Tony Blair's sons, got himself into a spot of bother years ago after his GCSEs or whatever it was, and was found a little bit the worse for wear. He was a teenager after his exams, and he was picked up by a police officer, and they do what police officers do, and they tell the newspapers, don't they? Because that's what. And I remember at the and it was and at the time, Mr. Blair was pushing the whole ASBO respect agenda. But he went on TV, the charismatic politician that he was, and he said, look, my son's basically a good kid and his family will sort him out and it'll be all right. Quite right. But I would have liked to see the same sympathy and empathy and humanity extended by Mr. Blair to the antisocial teenage kids of other people as well.
Can we look at another aspect of the trial process, not specific to criminal justice, but across the civil domain as well? We have recently had secret trials introduced. I'll ask Shami first. Do you think there can ever be a justification for a trial that's held in secret?
You know, to me, a secret trial is not a trial. Now, I understand that, you know, there have always been certain compromises that you make within an open trial. You know, we've had public interest immunity, and there are, you know, sometimes screens used to protect vulnerable witnesses and so on. But a closed trial, a secret trial, to me is anathema. It is not, secret justice is not justice.
Have you had to adjudicate one of these, Brian? Have you been involved in the mechanics and workings of
I've
one
not.
of them?
I didn't try one at first instance. The problem has become much more real over the last few years. I am not a million miles away from Shami. I would be horrified if we had a trial in secret, but I am prepared to recognise that there can be circumstances in which some of the evidence
Sure.
might have to be heard in secret. But there have to be protections, and it's rather interesting this that I'm merely reciting, I'm not commenting upon a recent decision of the Court of Appeal which reversed a decision that which was to hold a trial in secret, that it now may not be reported, but actually journalists will attend, and then a review will be undertaken at the end to see how much actually can be put into public domain. I think we've got to be flexible in this area because...
But we've been so forgive me, Brian, because this has been such a love-in that it's time for me to mix it up a little bit. I think that secrecy spreads like a contagion, and it has spread like a contagion in recent years through our justice system. And I say that partly as the guilty woman who, as a young Home Office lawyer, worked on the Special Immigration Appeals Commission Act. That's where, you know, that was one of the big, early developments in so-called secret justice. Mm-hmm. And then after 9/11, the contagion spread. And the secret state loves secrecy. And things really came to a head when the scandal, that is Extraordinary Rendition, which isn't beautiful singing, by the way, or wall plastering, it is kidnap and torture. And it was perpetrated in freedom's name by the United States and the United Kingdom security services and governments. And that was exposed by a combination of litigation and journalism. And some people got very, very cross about being exposed and being castigated by our senior judges. And what you then had after the 2010 general election was payback time, and that was then the Justice and Security Act. And I think, I feel very, very sad about it. And we have that now on our statute books. It is possible that someone could want to sue, for example, the police or the security services in relation to their bad treatment. It is possible that with ministerial certificates and so on, someone could have a whole trial practically in secret, where the claimant who claims torture or mistreatment is not in court. Their lawyers are not in court. There are government lawyers and a judge in court and a special advocate who can't talk to you and tell you what's going on. That to me is not justice. That is like, if you think of a judge as a referee, how can even a referee deliver fairness if one party is not on the pitch? And the other party, so you've got this darkened stadium with a referee and one team taking shots at an open goal. That to me is not justice.
But Shami, if the justice that you're talking about is the public interest justice, that the trial should be seen to be conducted in open, how do you preserve the other very real public interest, which is that secret material, properly secret material, does need to stay secret?
Well, public interest immunity. If it compromises national security, that submission on this evidence should be made to the judge, and if the judge agrees, then that evidence is not disclosable. And if the trial can't go ahead, it's better that it doesn't go ahead, that we have this mockery of
But that is
secret
precisely
justice.
the logjam, isn't it? That if the material is so secret that it can't be disclosed and can't be relied on, so the trial eventually can't go ahead because
Yes,
the material's at
and
the heart
that
of
to
it.
me
But
is
what if that is the material that answers the very issue that's raised in the case? In other words, the court can't really help in that circumstance.
But
There's
that's
nothing that can be done.
But that's facing the fact that on that occasion there cannot be a civil action. There cannot be, there cannot be justice rather than.
Or there cannot be a defence to a civil action.
Exactly.
Well, no. But if there can't be a defence to a civil action, that means without this material being disclosed, there's enough material to suggest on the balance of probabilities that the state has been up to no good. And that's why they settle cases.
But what if it's the other way around and you simply say, well,
So I say
the
I've
issue
been
in the case
tortured.
cannot be arbitrated? Does that mean that you just say this is a case that cannot go ahead?
So I
because
say
we
that
can never find the facts.
I
in
say
this
that I've
case.
been tortured. I claim that I've been tortured, and I want to sue the state. And I ask for discovery of relevant documents, and a judge is satisfied that if this discovery were made, national security would be compromised, and that cannot happen. Then if the judge is satisfied, then that trial won't go ahead, and I will be upset. And if enough people are upset, there may have to be an inquiry.
That's not a bad thing.
Which is not a bad thing, obviously. But I just really worry about this contagion of secret justice, because it is not justice.
Can we talk about public law and move out of secret justice into what I hope is more open justice and the constitutional balance as we see it now between judges and government? There has been a huge rise in the number of challenges to government decisions through judicial review. And I really wanted to ask you both for your observations on that. Brian, you sit as president of the Queen's Bench Division, which is where, in the end, these challenges come to the Administrative Court, which is part of the QBD. Do you think that the judges for whom you're responsible are conscious of this great rise in the challenges to government?
There's no doubt about it, and I look at the statistics every week. When I started at the bar in 1970, to apply for judicial review, you had to turn up into the Lord Chief Justice's court, who was sitting with two judges, two High Court judges, to ask for permission. And he would knock half a dozen of them out in half an hour, whether granting permission or refusing it. And then if he granted it, you got a hearing again in front of three judges. Now, judicial review is tried in the main, not always, by one judge, and I've got 9 or 10 judges every single day sitting doing challenges, not just to the national government, but also to local authorities and other public bodies. The grounds upon which judicial review can be pursued have expanded sensibly, rightly, in my view. Actually, possibly I should have said that because the government think otherwise, don't they?
They do. The government.
You are allowed to defend jurisprudence. I think you're allowed to defend the decisions of your fellow judges. Yeah.
There is no doubt at all that we are prepared to investigate far more than we were prepared to investigate, and we take the government say so far less
more scrutiny.
with rather more scrutiny, and the growth of judicial review has been one of the enormous developments of the last 25 years. And as the government intrudes in more and more of our lives, I believe that it is inevitable that it will continue.
Look, if there's more administrative action because the state is doing more, then there's going to be more judicial review, and that's right. You can't, if there are people who have so many of the major power relationships in their life with the state. If you live in state housing and you're on benefits and you have and you're a refugee, or you know, there are all sorts of reasons why the most important relationships in your life are with the state, and it's not a level playing field, and the law should protect these people, and the law should try and protect people from abuses of power, and therefore I think it's inevitable that there's been a growth in judicial review as there's been a growth in state activity, because otherwise there would just be abuses of power, and the evidence suggests that. I think that I think that the other thing is that back to this idea that it's somehow anti-democratic to have judicial review and to have judges interfering in the decisions that are made by government. Remember, there is this sort of fairy tale in our constitution, and I love fairy tales, by the way, but the fairy tale of our constitution is called parliamentary sovereignty, right? And it's a beautiful fairy tale, and I kind of believe in it, and I believe in Father Christmas too, but the reality is that I always put those presents in my son's stocking, and the reality is not of parliamentary sovereignty, it's of executive domination. It's of whips and payroll votes, and so the rule of law becomes an even more vital check on executive power.
I just ought to add that there are ways of challenging government decisions far beyond judicial review. The tribunal system has mushroomed in the last 25 years. So tribunals that govern immigration and asylum, that govern benefits, tax, welfare, like special needs children, information, all a wide range of activity where effectively the defendant is the state in some form.
We must talk about the convention, and of course one reason why the judges may have a bit more to do at the moment is because many of the challenges are brought on the basis of the European Convention. There's been an awful lot just in the last few days about where we're going with the Human Rights Act and with the convention. We have to ask you, Shami, I have to ask you, what is your reaction to recent initiatives that this country should either persuade Strasbourg that its judgments are not any more than being advisory, and failing that this country should depart from the convention altogether?
Well, I hate to say it, I'm shocked but not surprised. And my answer to the Prime Minister and the Lord Chancellor is actually this book, because this was coming. You know,
right. This has been a long time
coming. The phony war has been around for a long time. There was talk about scrapping the Human Rights Act and replacing it with a British Bill of Rights and Responsibilities and common sense. But there was just no detail. And now, of course, at least we have what passes for detail in their proposals. So judgments of the Court of Human Rights in Strasbourg will be advisory, and there'll be all sorts of caveats on who benefits from human rights protection. And make no mistake, this is not just about clipping the wings of the Strasbourg court, it's about clipping the wings of our domestic judges too, and their ability to take into account human rights jurisprudence from Europe and around the world. I mean, just to be clear, the Human Rights Act is the document that allows British judges to adjudicate on rights and freedoms here. And before we had a Human Rights Act, people used to take decades to get to the Strasbourg court to have their human rights protected and adjudicated on. And so it's a terribly, so it's actually it's a kind of Eurosceptic's own goal if you scrap the Human Rights Act.
Because it takes us back.
Because then you go back to the status quo ante, where you have to, you know, if you say that your liberty's been violated, contrary to Article 5 of the Convention, you say that your free expression's been muzzled by a domestic statute or the decision of a minister, you're going to have to go to Strasbourg. And now we're told that once you get your judgment in Strasbourg, that will only be advisory. What kind of a rule of law is that? You know, the model that we have is, as it is, weaker than the protection that you get under the American Bill of Rights or the French Constitution or the German Constitution. This is absolutely staggering, which is why I think Dominic Grieve, who was until very recently Conservative Attorney General in the coalition government, in my view, I mean, I've worked for and against, so to speak, law officers for practically my whole working life, and I think Dominic is one of the finest attorneys general we've had in my lifetime, unceremoniously sacked before the summer for standing up for the rule of law. And for saying that you have to, the thing about the rule of law is, whether you're a kid on a council estate and it's a magistrate, or whether you're a prime minister and it's the Supreme Court or the Court of Human Rights, you don't get to pick which judgments you obey. You don't get to say, I like that one because I won that case, and I don't like that one. That is just not the rule of law. And I think that's what we're really up against with political elites in this country at the moment.
Brian, do you think that as you look back over the recent developments of human rights law, jurisprudence under the Human Rights Act particularly, have human rights had an unfair bad press, do you think, over the last few years?
Well, first of all, I ought to just explain that to go into too much becomes very difficult, because as a serving judge that has to follow what Parliament decides, it's simply not open to me to get into the debate. But one's got to bear in mind that the European Convention on Human Rights was actually written by British lawyers to reflect the English common law. And our jurisprudence has moved since the 1998 Act. The Act requires us to take account of decisions of the European Court, and I've not had a difficulty doing that, I don't think. Mm-hmm. My decisions haven't always survived, but I'm comfortable with that. I say to judges frequently, when they say that they've been reversed in the Court of Appeal, I say, well, you've just got to remember, the Court of Appeal may prevail, but that doesn't make them right. I have found enormous value in having to explain some of the decisions that I've reached in the context of the Convention's jurisprudence. Mm-hmm. I'm not sure, I have no doubt at all that it's changed the way in which we approach some of the issues that are thrown up, and I'm entirely comfortable with that. But at the end of the day, Parliament will decide what Parliament decides, and if I go back to my oath, according to the laws and usages of the realm, I can't pick and choose which acts of Parliament I like and which I don't.
I would just say just two more things by way of a plea to people here, really. The first is a domestic point. All sorts of vulnerable people in this country have been protected by the Convention on Human Rights. Even in my working lifetime, women who were rape victims used to be cross-examined by the men they were accusing in person at the Old Bailey, sometimes for days and days and days, until a case was taken to the Court of Human Rights in Strasbourg that this was contrary to Article 3, which is inhuman and degrading treatment or torture. Stop and search without suspicion. Peace protesters, this is anti-terror powers, talk about it in the book. Anti-terror powers to stop and search without suspicion were used against peace protesters and journalists until we got a case on in the Court of Human Rights, and the list goes on. That's the domestic point. The vulnerable do need hard-edged human rights protection that comes from the Convention on Human Rights, which was Churchill's legacy. The international point is this: do we want to be a great democracy leading the world when it comes to human rights? Why is human rights protection always justification for military intervention over there, but never for human rights protection or indeed refugee protection over here? And what will people like Putin do? What will these these countries in the Council of Europe that are younger or lesser democracies than us, how will they behave if Britain, perhaps arguably the oldest or one of the oldest unbroken democracies on the planet, cocks a snoop at the Convention on Human Rights? I don't know.
What I'd really like to do, members of the audience, you've patiently listened, and I think we would like to hear from you now. So if anybody was to have a question, please raise your hand. I think there's a microphone going around, and we'd be very pleased to hear your questions. There's one down here, there's one there. Thank you. Thank you. This is my pupil.
Thank you. I was just wondering, just on the jury point, the discussion of that, I wondered, are we perhaps too kind to the jury in that we accept it self-evidently as a good thing? I'm thinking of the fact that it's randomly selected. I'm thinking of the various sort of prejudices which may or may not be taken into a jury room, and in particular the fact that I think I'm right in saying that the Contempt of Court Act bans any disclosure of discussions. I wonder to what extent it's being too kind to it as an institution to say that it works and indeed is empirically proven to work.
Well, I didn't say it worked because I don't know. All I can say is that our democracy has grown up on the principle that serious criminal cases are decided by 12 randomly selected jurors. One thing I will say, and I recognise that certainly for the last 30 years, 25 years, 30 years, I've been trying serious, or either working in as a barrister or as a judge in serious crime. I've found jurors are incredibly sensitive to the issues. They work extremely hard. I know we've had stories about people tweeting and going on the internet, but and we've got to be careful about that, because we've got to make sure that jurors decide cases on the evidence, not on prejudice or what they might have read in the newspapers. But
you say that, I mean, I agree with you, that these are human beings, and so they're bound to have prejudices. But guess what? Forgive me, Brian, I'm sure that magistrates and judges have prejudices too. Yeah. So this is always going to be imperfect because we're human beings. And I don't think we should assume that a professional tribunal, when we're talking about, in the end, when we're talking about who do you believe, which witness is telling the truth and which is telling a lie, and a lot turns on things like that, doesn't it? I don't get that a judge or a magistrate will be inherently fairer or less prejudiced than 12 members of the jury. And I do think there's a legitimacy and a democratic engagement and ownership that is really important to the criminal justice system. To remember what Brian said, we have this system partly so that people don't go off and take the law into their own hands. That means it has to have this sense of legitimacy, and I think that's ultimately what the jury system delivers. There's
no question, but there have been occasions where jurors have misbehaved. There is no doubt about that at all.
Too.
Yes, yes, yes.
On occasion.
Well, I mean, the case that I'm thinking about the jurors, when somebody brought a Ouija board in. I don't think a judge will have done that. But it's rather like when a judge says something stupid, and occasionally judges say things stupid, then the press will bring out the 12 last occasions. And of course, there are always occasions. The fact is that we do everything in public with absolutely minimal exceptions, but really 99.999% is always in public. The press, anybody is there to report it, to say what they want about it. There is a record of it. And you can always pick out stupid things that are done, whether by juries or by judges. But if you remember that there are thousands of cases going on every single day of the week, hundreds and hundreds of jurors sitting patiently sifting through the cases day after day, the number of examples of misconduct are very, very small. That's not to say we haven't got to be on top of them.
Exercise in civic participation as well.
I agree.
How many opportunities do people get in their lives for that? This is a very elite audience. You're all clever people. You went to Merton. I'm sure you do really, really important jobs. But for a lot of people, this is one of the most important aspects of their civic lives, to have participated in that process. It's wonderful compared to people's engagement in party politics, for example, which is almost non-existent these days. I think it can't be underestimated.
I used to say to jurors, you've just reminded me, I used to tell jurors that this was, in my view, the highest duty of citizenship. Much more important than voting, which is very important, but there are 30 million people voting or potentially voting. Here, you are one of 12 people deciding on the future of a fellow human being, another citizen, and deciding sometimes some very, very difficult issues, and at great personal cost. Jurors who sit for months, or who tried the most harrowing cases, but just solidly plod on. So I see the problem, I understand the point, and there's a real issue because, of course, you're not allowed to research what juries do. But judges provide very, very careful directions to juries, and I'd like to think that everybody by that stage in the case has such a sense of responsibility that they listen to what they hear and they obey it. So I always talk about emotion and sympathy. The two very important human spirits which we don't take into a jury room. Cold, analytical job. Just the phrases that I used to utter to juries are coming back to my mind, but it's a long time since I was allowed to do that. So.
It's rather entertaining to me to listen to Brian talking about his experience in crime, which over a long period, either as barrister or judge, or in the Court of Appeal, CrimDiv, or whatever, has been dealing with the rather more serious end of the criminal spectrum. For those like me who have the odd outing as a recorder to Portsmouth Crown Court, were I to regale my jury with the gravity of their civil undertaking and obligation at the end of the 2 or 3 day fight case they've just listened to, I'm not sure they'd thank me greatly. And it is true to say that the level of commitment and diligence that I think you tend to see in juries does depend a bit on the sort of case and the sort of level that you're asking them.
That flows into the point that Shami was making and that I was making about making sure that the work they're doing is sufficiently serious so that they feel that their time is being well used. But I think even after a fight case you can say to a jury, you know, you may not have thought this is the most serious case in the criminal calendar, but you have just decided an important question which affects the liberty of this particular person. It's up to you.
I'll try that one.
It's a matter entirely for you.
Members of the jury. My next member of my audience. Yes, there's a question down here, please, if somebody could take the microphone down. Thank you.
Thank you. I wanted to pick up on something that Shami said in passing almost, which was that an extraordinary rendition was brought in liberties or in freedom's name by the people who were pushing for it. This brings up an issue for me, which is liberty can seem to refer to both freedom from state interference, but also freedom from the interference of other actors, whether it be terrorist criminals, antisocial sort of entities in our community. And if it's the state who's providing us freedom from those other actors, this language of liberty can be used to advance both the extension of state power as well as being used to argue for curtailing state power. Now, do you think that this sort of two-faced side of liberty is a strength in the concept, or do you think it's a weakness because it allows both sides of the debate to draw on this really powerful rhetoric?
A fantastic question. It's a strength. I'm not some uber-libertarian. I believe in human rights protected ultimately by independent judges in the rule of law. I believe in positive obligations on the part of the state to protect the vulnerable from the powerful. And that includes things like providing the court system and providing legal aid. This is all active intervention. This isn't leave me alone, oh, big brother state. You have to have criminal law and sex offences and violent crimes to positively protect people from each other. And that is, so human rights is, so the human rights framework is one of respect for autonomy, but also positive protection. And it ultimately is about protecting people from abuses of power wherever they come from. And that could be, you know, abuses of power in the home or in the police station. And that's what I think. I'm not a sort of small state libertarian and everything else goes. That's, you know, because that's liberty for the lion but not for the lamb. I believe in this precious positive framework of, as I say, respect and protection, and ultimately it has to be protected by the rule of law.
Do we have any other questions? Yes, lots. This is wonderful. Well, let's go to this gentleman here.
Thank Shami Chakrabarti for reminding us of the English and British origin of the European Court of Human Rights. I wonder, I'm not sure this is a question that can be answered, but I wonder to what extent politicians are playing on Euroscepticism by threatening to pull out of the European Court of Human Rights, which has, of course, nothing to do with the European Union.
I think you're complete. I think this is it's a beautiful question because you answer yourself, and I think and this is a very overtly political question, so I'm the one that can answer it.
Be careful, be diplomatic, because you're former head of the diplomatic corps.
So what I think is what I think is this: where both main parties in my lifetime. Both of our main political parties have at different stages been absolutely riven by this European question. So when I was a kid in the late 70s and 80s, it was the Labour Party's problem, as you know, and now in more recent years it's been a problem for the Conservative Party. And I think what happens is that on the one hand, the business supporters of the Conservative Party will say hands off the European Union because actually it's good for business. I'm not saying it is or it isn't, I'm just saying these are the voices one hears. So you have the business community saying to a Conservative Prime Minister, we want the single market, we like Europe, it's good for our business. But at the same time, you've got these other voices, and they're not necessarily just sort of xenophobic voices. Sometimes it's people who have understandable and legitimate concerns about unaccountable European institutions and accounts not being signed off and so on. So you've got the Eurosceptic element and the pro-Europe element. How are you going to square this very difficult political problem? Well, what you do is you deliberately do this distraction technique of saying it's all about Abu Qatada and sending people to places of torture, and it's all the wicked old ECHR, so that we can keep the single market for business, but we won't have the value system, the human rights value system. But I think this is the worst kind of internationalism, that you'll have globalization and internationalism are a reality in this shrinking, interconnected world. That's my view. But why should we only have internationalism for business and for government, but not for people and their human rights?
Where should we go next? How would you like to go next?
No, I'm happy to listen to Shami.
There's a gentleman right at the back. Can we come to you, please?
I thought we just said was but my question is that I was at a talk by Leveson, thank you, about a year ago, in which you said that there isn't room for statistical analysis in the effectiveness of sentencing. Because at the time you were talking about sentencing and how I was saying, how do you know what different sentences are effective or not? And I was wondering, could that be a talking point now of, do you think, like Obama has tried to bring into the political side of it in his administration, do you think there is time now to say, is this type of sentencing actually more effective? Just now you said, I don't know if jury is a good way of doing it. Surely that is quite an absurd way to have a legal system, or maybe it's not.
No, I was saying I didn't know whether the jury got it right because I wasn't there. As regards the sentencing, you've first of all got to decide what you want out of sentencing. What is the purpose of a sentence? You can say it is because the Montrose aim, which I spoke about before, there is a punitive element, there is a utilitarian
simple public protection.
Absolutely.
There's deterrence.
And there is deterrence, both general deterrence for the public and individual deterrence for the individual. And there's also rehabilitation. And of course, in an ideal world, one would want to ensure that although you send people to prison as a punishment, but not for punishment, while in prison, efforts are made to rehabilitate them. But you have to understand something about the prison population. And the first thing you have to understand is that almost everybody in prison, almost everybody, has a constellation of problems. They are illiterate and innumerate. They suffer mental health problems. They have horrific family backgrounds. They are unable to cope in the 21st century. And of course one tries to help as much as one can, but the money available is reduced. The important priority is to detain, to make sure that people can't run away and escape. Therefore, what gets lost is the education and the other rehabilitative mechanisms that are in place. 40 years ago, my father, who was a consultant psychiatrist, was complaining about the fact that the government of the day were shutting long-term psychiatric hospitals. And he said to me, we can do this, but one thing I promise you is that my patients will be silting up your prisons. And that's exactly what's happened. And
wisdom clearly runs in the Leveson family.
Which really these things to support that there should be more analysis to say, well, sentences are getting longer. Does that actually mean that there's less public upset at the sentences given? Maybe we should be looking at different views of sentencing people.
well, I'm perfectly happy to do that. What do judges do? Judges take the sentencing regime prescribed by Parliament, and what we're very good at is making it consistent so that this robbery gets X, yet this lesser robbery gets Y. And if the robbery is getting X, what's the equivalent in theft or in violence or in sexual offending or in fraud? To try and ensure that the system is fair, and as between defendants, what is fair. I used to, when I was chairman of the Sentencing Council, I used to make speeches about the importance of consistency of approach to sentencing. And one of the things that you can find out about how we sentence is go to the sentencing guidelines, which are now very clear because they identify how judges approach sentencing. To test effectiveness, what do you mean by effective? That somebody never offends again? That somebody doesn't offend for a year? That somebody's offending is reduced?
Well, all these things are good ways of testing each other.
Well, but how then are you going to compare where you get a drug addict who's weaned off drugs, who does extremely well for 9 months, then collapses?
But should we use all criticisms of, say, a drug, a long-term drug, say Alzheimer's, and say there's so many other factors, and say, well, that's true, but you try and reduce the effect of those factors by having many, many more tests.
Sorry to cut in. When I'm listening to this, I'm hearing this very, very intelligent dialogue beginning about the purpose of sentencing and about what the penal system ought to be doing for society. But there's this other voice in my head, which is the former Home Office lawyer who was responsible for churning out lots of really knee-jerk criminal justice legislation. I have to tell you, the legislation that I worked on rarely came as a result of discussions like this. It came more out of just knee-jerk politics and populism, and you know, a little girl gets murdered, a bomb goes off, whatever happens, and the cry goes up, mediated by the media. Home Secretary, Prime Minister, what are you going to do to make sure that this never, ever, ever happens again, right? And then the politician goes off to the TV studio or the dispatch box and says, fear not, because I will be back in a week's time with a new piece of legislation, right? And you can understand, they're not bad people, they're just people. And the temptation is great because talk is cheap and legislation is almost as cheap. But it doesn't mean that it's well thought through or that it is actually the right response in that moment.
Ladies and gentlemen, there were more questions. I fear we're not going to get to them, but I hope that Shami and Brian will be here afterwards if you would like to approach them and pick up your questions then with them in private. But I think our moment has come to wrap up the evening of conversation, and I know Martin wants to come and just say a few words to complete that task.
So, ladies and gentlemen, I'm quite certain you would agree with me that we have had an outstanding Merton conversation. I sense, just as you said, Philippa, that we could have gone on for a very long time yet. The team has really engaged people, and I'm very grateful for that. With the topic on liberty, I wasn't necessarily sure I was going to be greatly amused or greatly entertained, but I've been greatly amused and greatly entertained, but also at perhaps a deeper level as well. I was expecting a thought-provoking discussion, and we got a very thought-provoking discussion, but it was also very touching. The bit on humility sort of really went down into my soul, and the discussion on human rights, as Patrick raised, was really kind of gripping indeed. I am not a lawyer, and I like to think that I would get a nugget or two out of something that's not my field of expertise, and I did. I learnt how law affects the lives of people very deeply when they come in contact with the law, and how vital it is that they go away with a sense that justice has been dispensed. I got that, as it were, graphically. Now I want to sort of come to the team in particular, the particular individuals, and I want to start with you, Philippa, because yours is the job that I have had to do. I was a moderator at the Royal Society, and I would have to confess to you, I used to have a morbid dread that it would dry up on me. Anyway, you kept the flow going extremely well, which is probably, that's the great test of a moderator. But in particular, I also want to thank you for the superb presentation that you got us all going off with, and especially touching on the Magna Carta and that symmetry with our statutes. I thought that was absolutely terrific. So we have what we would normally call gifts for the team, but in these hallowed precincts, I'm going to call them awards. And then you can all go home and tell your families you got BAFTA awards. But now the big trick also is for me to give you the right ones. So just looking very hard here. So there we are. Yes, yours is right at the back, of course, yes, Philippa. So Philippa, your BAFTA award. Can we have a round of applause?
Thank you very much indeed.
Well done. And now I want to come to our two discussants, and I want to thank Brian and Shami for their insights, their great humour, As I say, I keep on with that. I wasn't necessarily expecting great humour. I loved it. The wonderfully articulate discussion, and I just thought it was quite superb. So let me now make 2 more BAFTA-like awards, in case anyone sort of challenges me. So, Brian, this is for you.
Thank you very much.
Don't open it now. And for you, Shami, thank you very much. Well done. And now I want also to thank you, the audience, because as I say, you're a very engaged audience. We could tell from the questions. And I also have to remind you of something, that the next and therefore the final Merton conversation, which is entitled The Real Science Behind CSI, will take place on the 11th of November at the Royal Institution. I'm looking forward to that because I'd never seen BAFTA before and I've never been inside the Royal Institution either. So please do hold that one in your diaries. And now another great treat comes up. I want to invite you to all join us for drinks and canapes in the David Lean room. Come join us. Thank you.